Federal and state courts have separate judicial processes, legislative processes, and administrative processes. These processes vary from one state to another. We've discussed the judicial process in relation to sources of law and judicial review of agencies' regulations and adjudications. This section discusses other aspects of the judicial process, touching on statutory and administrative issues. We've previously discussed the separation of powers, the constitutional structure dividing the federal government into the legislative, judicial, and executive branches. The founders built this tripartite structure in order to protect liberty by ensuring that no one government actor or faction can exercise overwhelming power. But the second part of the decentralization of political power is federalism, the separation of powers between the federal government and the state government. The founders intended the states to exercise most of the political power over most natural subjects of government regulation. So, state governments regulate most commercial transactions, contracts, and corporate structures. States and their creations, local governments, regulate ownership and transfers of land. So, deeds and mortgages are registered with state and county register of deeds offices. States license skilled trades and professions. The federal government exercises nationwide power, but initially that power was limited to only the enumerated powers set forth in Article 1 of the Constitution.